Okay, hello everybody, good evening. I'm Shona Douglas-Scott. I'm a professor here in the law faculty, and it's my very great pleasure to welcome Professor Eve Darian-Smith from the University of California, Santa Barbara, to give this year's Cotterrell Lecture. I'm going to say a little bit about the Cotterrell Lectures, and then I'm going to introduce Professor Darian-Smith. The Cotterrell Lectures in Sociological Jurisprudence are named in honor of Professor Roger Cotterrell, who for many years has been professor here at Queen Mary and also has had a stint as Dean of the Faculty of Law, I believe, in the 1990s. And we're very glad to see him here tonight with his wife, Anne. Roger's work will be very well known to most people here. In 2013, Roger was awarded the Socio-Legal Studies Association Lifetime Achievement Award for contributions to the socio-legal community. And I think for so many of us, his work has been really inspirational, whether relating to law and culture, law and community, or his excellent book, The Politics of Jurisprudence, which I'm sure was for many, as it certainly was for me, the work that got us really interested in jurisprudence. Sociological jurisprudence in these lectures is understood broadly as encompassing any aspect of socio-legal studies, any serious effort to relate jurisprudence and legal theory to changing social and historical conditions, or any topic linking law and social theory. And in this context, Professor Darian-Smith is giving this evening's lecture. She's professor and chair of Global Legal Studies Department at University of California, Santa Barbara, and I believe you're also an adjunct professor at ANU. Trained as a lawyer, historian, and anthropologist in Australia and in the United States, including at Harvard, where her supervisor was Sally Falk Moore. She's interested in issues of post-colonialism, legal pluralism, and socio-legal theory, and has published very widely, including 10 books and many, many articles. Her book, Laws and Societies in Global Contexts, Contemporary Approaches, won the 2015 International Book Award. And her latest book is New Indian Wars, Indigenous Sovereignty in Global Perspective. The breadth and depth of her scholarship is immense. To give an example from just one of her books, Religion, Race, Rights, the chapters span Martin Luther and the challenge to the Catholic Church, the Nuremberg trials, slavery, colonialism, and sugar. And she's given many, many distinguished lectures all over the world, and now she's about to give another one to us, talking about islands of law, seas of humanity, law in a postnational world. And we welcome Professor Eve Darian-Smith.
Thank you for that very, very warm and welcoming introduction. And it is truly an enormous honor and privilege to be here because I, like many people in this room, have been very much influenced by Roger's work, and it has been truly inspirational since many years. So thank you so much for inviting me. It is really very humbling to be here. I thank you very much. Today, I'm hoping to push the conversation about law and transnational law, of which Professor Cotterrell has written extensively, a little bit further along in the hopes that we can think about law in a post-national era, which is what I will talk about in a bit further on. And I want to reflect upon the current conditions of our world order and how these conditions and what they sort of suggest with respect to thinking about legal theory as it engages with law beyond the nation-state border. However, I want to come to this topic from a slightly different angle. For unlike many prevailing conversations in legal law and theory, which typically take a top-down and a rather elitist perspective in analyzing what we mean by law and by extension transnational law, I want to push a bottom-up perspective that in many ways reflects my training in anthropology and, this is pretty corny, my down-under perspective on the world. I just had to put that in there. So a lot of the legal theory talks about merchant law, about trade and financial instruments across borders in a very sort of top-down, and I'm going to try and bring the bottom up. In other words, I want to ground conversations about what constitutes transnational law in the messy realities of ordinary people and everyday conflicts that we are all now currently confronted with and can no longer ignore, even if we operate only in the echelons of elite legal activity. In my talk today, I want to first talk briefly about what I mean by postnationalism before engaging with what I call a global socio-legal perspective. And it was mentioned in the introduction, I've written about a global socio-legal perspective in my book, Laws and Societies in Global Contexts, and it represents my current thinking about the complex relationship between law without, beyond the national borders, and law within as it impacts everyday people's lives and experiences. I then want to illustrate what I mean by a global socio-legal perspective by comparing concerns over migration in Europe back in 1995 with the current refugee crisis. For as we are all very much aware, only 20 years ago, the EU, which was then only 15 member states, showed much promise as an illustration of regional transnational governance. Now, of course, it is under severe strain and stress, and some may even argue potential collapse. This shift in the EU's fortune points to the need to rethink changes in the world's geopolitical map, both within the European context and beyond, as well as a need to rethink our conceptual and intellectual maps that cling to a modernist legal paradigm and what I want to suggest is an anachronistic socio-legal framework. So we're living in what more and more commentators are calling a post-national world. And by this I mean post-nationalism is referring to a diverse range of legal and social relationships brought about by new labour markets, new industries and commodities, new forms of secular and religious violence, new cultural and sexual politics, new reproductive technologies, new materialist understandings of agency, and a rethinking of the autonomous subject-citizen, with increasing attention being given to a blurring of conventional divides between the human and the non-human. In other words, post-nationalism is a sort of word that's being used by more and more theorists, which is really a sort of shorthand tag for a whole sort of constellation of new legal and social relationships that are emerging in the 21st century. What is becoming clear is that the idea of a person's legal subjectivity and identity being constituted solely through the geopolitical boundaries of the nation-state is no longer a given in a post-national world. In other words, we can no longer pretend that the modernist concepts of individual and state are stable categories and share clearly demarcated relations that up until relatively recently have underscored the idea of state nationalism. In short, how people conceptualize themselves is now widely acknowledged by ordinary people as not reducible to simplified and essentialized individual and group identities recognized in law through state policies and institutions. Related to the breaking down of concepts of individual and state as stable legal concepts is also the breaking down of the notion of a social contract between subjects, citizen subjects and nations. And despite a lot of criticism that has emerged, and I'm here thinking of people like Carol Pateman and Charles Mill around the idea of a social contract. Up until relatively recently, the idea of a relationship between the subject citizen and the state as a defender of a person's rights and the obligation between the two has been relatively well received. I mean, it's been a sort of constant in liberal legal philosophy for a couple of hundred years. But now with the stark realities of neoliberal economic policies, the dismantling of the middle classes, and a very much a widening gap between the rich and poor, the concept of a social contract has come under mainstream attack. In the United States, growing popular disillusionment in the law as a vehicle for democracy has been expressed across the conservative and the democratic progressive political spectrum in Tea Party and Occupy activist movements in recent years. Mainstream American society now seems to have woken up to the fact that law can be managed and manipulated to justify torture, deny workers a living wage, gather unlimited data on one's personal life, and protect oil companies whose irresponsible practices cause billions of dollars of damages, and protect them from liability. So I think there is an increasing awareness in the last couple of years within US society that law isn't the harbor of all good things, that the liberal promise has really come under attack. And we can talk in the question and answer period about Donald Trump if we have to. Outside the United States, there is a similar disillusionment in law, which is widely viewed as an instrumental mechanism of power and a technical apparatus that serves special interest groups. And the person who gave this lecture last year, Brian Tamenah, he has written extensively about this issue, and he reminds us that we are now facing, this is a quote, the rule of some groups over others by and through the law, more so than a community united under a rule of law that furthers the common good. In other words, the notion of a common good has increasingly become distanced from how people think about their relationship with each other under the umbrella of the nation state. In short, there is a looming crisis in the legitimacy of Western legality as the checks and balances envisioned by a system of representative governance are proving to be clearly inadequate. Now, of course, I don't want to suggest by any means that concepts of individual and state and nationalism are no longer relevant in contemporary politics and legal thinking. But I want to suggest, as have others, and certainly people in this room, that the taken for granted Western concepts of Enlightenment thinking are now being contested on a number of fronts that include critiques from the global South and East, and an increasing appreciation of the deeply embedded histories of oppression and inequity in our globalizing world. And there's enormously exciting literature coming out of people involved with indigeneity and British settler colonialism, showing sort of intertwined global histories around the world of colonialism and enduring colonial oppressions. Autonomous sovereign states, autonomous sovereign individuals were living within those states, and the imagined communities, to borrow from Benedict Anderson, that supposedly bind states to people through narratives of a monocultural society are increasingly being recognized as anachronistic and not reflecting the lived experiences of many people who are in a post-national world. What this constellation of social relations highlights, this new constellation of social relations highlights, is that our legal categories, grounded as they are in the nation state, have not yet caught up with the messy, ambiguous realities of post-nationalism. In mainstream politics and policies, as well as in legal education in many law schools, I'm sure it's not the case in this law school, but certainly in many law schools that I've experienced in the US, there is still a tendency to think and act as if we live in sovereign autonomous states, or what I would call islands of law. These islands are conceptualized as discrete geopolitical entities with clear borders and a clear correlation amongst jurisdictions, legal systems, and territories. And we just have to think of a very standard map that is used in comparative law classes still. This is what students are shown. This is this notion that you have civil law and common law or Muslim law that correlates to particular continents and regions and geopolitical spaces, some of them regional, some of them state. But this map is a very, very taken for granted illustration of how legal systems operate in the world. And of course, it is a map that is highly, highly contested. If anyone just wants to think about it and probe those notions of law, territory, and state. Of course, in reality, countries are comprised of plural legal systems, all countries, and all countries don't act as independent operators, since they all, to various degrees, rely upon other countries' cooperations beyond their borders with legal agencies, legal actors of all sorts, not just other states. Each nation participates in the UN, various networks of international organization, regional trading blocs, perhaps even the International Criminal Court or the European Court of Human Rights. Each country around the world operates in spheres of interlegality, to borrow a term from Boaventura de Sousa Santos. But that being said, so that's the reality. Each country has legal plural systems operating within its borders, even if they're unrecognized. It is still the case that each country typically, and particularly the rich countries of the global north, acts as if it has the right and privilege to go it alone, and if required, can retreat within its domestic realm, hunkering down, waiting out the crisis, and pretending that the rest of the world will not impinge or impact them. And I just had to show that picture. My point is that such a head-in-the-sand mentality, typically pushed by more conservative political elements in any society, is blinkered and ultimately leads to conflict and violence that threaten each and every one of us, not just the stateless refugee or the asylum seeker detained for years without hope of access to legal representation. The recent attacks in Paris and elsewhere around the world, of course, are nurturing escalating fears, and it seems we are all increasingly trapped with no real path forward other than increasing military spending and retreating selfishly inward, both in terms of our personal empathy to think with others and in our complicit participation in the building of higher walls and zones of exclusion. So, how are we to proceed? And this is where I want to explicitly engage with the concept of transnational law. In looking at how the term is used, what has struck me is that in much of the literature on transnational law, the concept of the nation state is taken as a given. It's a naturalized concept. It's sort of the beginning point that people grasp onto. Certainly many scholars are analysing new combinations of national and international law and new legal relations beyond and below the level of the nation state. And certainly many discussions touch upon how these new legal relations are disrupting conventional divides between public and private law and informing new modes of relational connection between laws and societies. But that being said, most socio-legal analyses are still very much anchored in state institutions, state actors, and state power. And many of these discussions echo the core periphery models of 20th century development strategies. This suggests to me that we are, I think unfortunately, ultimately still caught within a modernist paradigm. So while we talk of a post-Westphalian law a moment, and we recognize the destabilization of the nation state and the emergence of a range of new global processes and sets of personal and collective political relationships, in mainstream politics, we are still anchored to a national imaginary and its intellectual histories and legal legacies of internationalism. So we're still, in many ways, grounded within that UN perspective. So why is being moored to a national imaginary of concern? Why do I even want to talk about this? What's at stake here? Who cares if we hunker down and through non-action fall into step with our political leaders as they build higher walls and spread a sense of crisis? Quite apart from the moral outrage we should all be expressing as spectres of fascism come more sharply into focus, my argument is that such complacency limits our ability to expand the horizons of jurisprudential thinking. By anchoring ourselves to outmoded concepts, we fail to see what I would argue are pervasive and growing global challenges to ideals such as democracy, equality, and freedom. Moreover, I think this is the second sort of part of my argument, we also fail to recognize emerging counter-hegemonic impulses and alternative legal and social ways of being that may offer us insights on how best to deal with these challenges. Remember, I'm not suggesting that national contexts are no longer meaningless. The modern nation state has framed legal philosophy and practical understandings and meanings of legal concepts for a few hundred years. Moreover, as the rise of right-wing xenophobic nationalism around the world attests, a retreat to and a shoring up of the cultural, political, and physical boundaries of the nation state dominates much of our geopolitical landscape. It is precisely the context of new global forces that states are escalating their border controls and claims of territorial sovereignty. So this hunkering down, this building of walls narrative that you see in many, many political conversations. Obviously, Donald Trump talks about the wall, but it's very pervasive, this notion of border controls. It's precisely because the nation state is under deep challenges. So I want to argue, along with others, and here I'm thinking of the groundbreaking writings of Wendy Brown, Judith Butler, and Saskia Sassen, that these nationalist framings and their embedded temporal and spatial orderings of social life are no longer adequate. What I'm suggesting is that the limits of our nationalist-based thinking needs to be acknowledged and seen as an obstacle to more inclusive and progressive political activism. And congruent to this recognition is a need to think about a more complex and pluralist understanding of what we as socio-legal scholars are prepared to recognize and respect as law. And here I'm thinking, of course, of some indigenous work that I've done on different concepts of law and how it relates to land and space and time. And certainly there's very exciting work done on law and religion that also brings in a completely different framing from the secular Enlightenment models that we're very much used to. So now I want to talk about a global imaginary. And I want to suggest that we need to adopt a global imaginary that will by necessity force us to question our taken for granted assumptions surrounding the production of legal knowledge and how we think we know and claim to understand law. The first point about a global imaginary that I want to make is that it is something different from an international and a transnational imaginary. The international speaks to the interactions between nation states, and of course think of the United Nations here, while the transnational typically speaks to the interactions beyond the nation state, while still using the nation state, to anchor its imaginative reach. So what I'm talking about is something different. In contrast, a global imaginary includes nation states, but also a huge array of non-state actors, organizations, collectivities, processes, relations, ways of knowing, modes of interaction between and within national and transnational contexts. In this way, the global, I think I'm suggesting, should be thought of as conceptually and epistemologically more encompassing than the transnational and the international, which are still anchored primarily to the core concept of the state. Hence, a global imaginary exists in uneasy tension with a national imaginary and in fact intrinsically challenges its presumptive authority and centrality. The second point that I'm hoping to make is that we need to complicate how a global imaginary is typically talked about in mainstream society and media. Most people think of the global in geopolitical terms, in spatial terms, and correlate it to processes and concepts that transcend the borders of the nation state. The global is often talked about as involving a global, as in a worldwide spatial reach, and today has become synonymous with processes of globalization and corporate finance and economic activities beyond the state. In contrast to this overarching geographical conceptualization of the global, I suggest that it is not a matter of spatial scale or geopolitical reach that makes any law or legal process global. Global, in other words, doesn't just mean big. The local and global are mutually constitutive, creating and recreating each other across conceptual fields in a constant dynamic. This means that the global is not only found in large macro processes, but can also be found in the full range of human activities. So we don't find global processes only in large cosmopolitan cities and multinational corporations, but also in villages and in neighborhoods and workplaces and private homes. My argument is that the global is present where global scale processes become manifest in real-world contexts in the lives of ordinary people. Putting it another way, what makes a law or a legal process global are the questions one asks that reveal its global dimensions, even if on the surface it appears very small scale and localized. So in reflecting upon a global socio-legal perspective, it is important, I think, to note that it is something much more than a nesting of geopolitical scales and jurisdictional levels from the local up to the global. Rather, a global socio-legal perspective involves a new conceptualization of legal practice within a global imaginary. This involves, as Saskia Sassen has argued, new assemblages of authority and power that do not privilege one spatial dimension or orientation over another. Hence, depending upon the questions one asks and the legal issues one is engaged with exploring, the local may occupy the foreground and in fact eclipse the global in terms of analytical and methodological priority. Moreover, the local may in fact impact the nation in ways we do not yet appreciate. This recasting of socio-legal relations, I think, creates opportunities to move beyond conventional linear notions of cause and effect, since it cannot be automatically assumed that nation-states are the central and most powerful actors. In the process, what becomes disrupted is our instrumentalist view of legal processes that in most socio-legal scholarship primarily still emanate from the nation-state and are typically interpreted as making an impact either up or down a vertical spatial scale, an axis of sub-state, nation-state, trans-state legislation and legal relationships. So that's my sort of global socio-legal conceptualized map, and I now want to talk a little bit about migration and thinking about that in the context of this conceptual framework. So this takes me back because this is the doctoral work I was engaged with about 20 years ago. And in the early 1990s, I was doing graduate research exploring the impact of the EU on notions of English national and legal identity. That time, it was the period in which John Major, some of you will remember, was the Prime Minister. There was only 15 member states in the EU, and Britain was experiencing very heated political debates, as it continues to do, about the value of being in the EU. And there was strong Euroscepticism amongst some of the Tory members. My work focused on the building of the Channel Tunnel, which symbolized two competing responses. On the one hand, the tunnel evoked fear. Fear that the historical borders between England and France were being broken down, and along with that, the autonomy of the island nation. On the other hand, the tunnel represented hope. Hope that the very dismantling of borders would create transnational connections and new opportunities for British people in terms of jobs, education, and lifestyle. These contradictory emotions and forces, fear and hope, became emblematic of the EU's regional transformation. And there's the elite business class catching the Eurotunnel. Over the past 2 decades, these contradictory emotions of fear and hope have, of course, intensified. Ongoing wars of terror across Europe, the Middle East, and the African continent have marked a chasm of difference between the neoliberal optimism of unregulated global trade and finance in the 1990s, of course brought in with Reagan and Thatcher, and today's increasing pessimism of what such neoliberal logics have waged for the poorest sector of the world's populations. The logics of economic free trade and exploitation promoted by the so-called Bretton Woods institutions have come home to lay waste to the European heartlands of Greece, Italy, and Spain. The world is certainly a very, very different place from what it was 20 years ago. Then the migration or immigration crisis of largely North Africans trying to cross the Channel Tunnel from Calais was seen by the English media and press and population and the British government in particular as a rather tiresome, tedious, and isolated problem that could be ultimately controlled. So Calais and the immigrant communities that were mobilizing on the borders there trying to get across the tunnel was seen as, you know, it was a problem, but it wasn't actually that difficult because ultimately the White Cliffs of Dover, the channel, the water would separate the country from the continent. And then so the image of the borders here was extremely important. Then euphemistic narratives of rabies, this is in the 1990s, and disease flowing into the UK from dirty continental Europe prevailed. I have to show you a picture there. These were narratives which today seem rather quaint in comparison to the open brutality of Marine Le Pen and other right-wing political parties across Europe. Back then, it was still widely believed that despite the building of the Eurotunnel, the open waters of the channel would provide the ultimate buffer zone, protecting the integrity of the island nation and its unique cultural and liberal legal system. Now the so-called jungle of Calais reflects just one hotspot in a refugee crisis which no one can imagine an appropriate response or solution. It is no longer possible to pretend that the borders of any one country or the borders of the EU stop at the water's edge. As a result, military forces are patrolling the open seas, and frantic negotiations to set up roadblocks in Turkey and sites beyond the EU are being negotiated, as we are only all too well aware. Today, new sorts of violence and racism have erupted in the spaces opened up by the law's obvious inability to sustain its liberal promise and protect modernist ideals of monocultural nationalism. We are living in an era of what Stephen Verderick calls superdiversity, that is recasting the cultural politics of nation and social organization against a backdrop of mass human migration and the complex melding of religious and ethnic plurality. As we have all witnessed in the world's response to refugees, superdiversity highlights anxieties of state nationalism and that are manifesting globally in xenophobic and brutal state policies of exclusion. What people in the global north seem to have only recently realized is that we are now in the middle of what is called a global migration crisis. The Office of the UN High Commission for Refugees stated last year that as of mid-2015, there are now 61 million people on the move. Nearly 14 million people were newly displaced in 2014 alone, the highest recorded in the UN agency's 50-year history. What these horrifying and startling figures do not immediately show us, however, is that the crisis has been steadily unfolding for some decades. So while we're experiencing it, and certainly in America, people are experiencing it as something new, and of course this has been going on for many decades, this movement of mass peoples. It's just now that rich countries are truly feeling the brunt of it. Not only has there been a refugee encampment in Calais since 1994, off and on, being dismantled, but it has been there in some form or another since 1994. But around the world, in both rich and poor countries, detention centres have been set up to house the mass movements of people fleeing conflict. This is a detention centre east out of Perth in Australia. These detention centres exist in Britain, such as the controversial Yarlswood Detention Centre established in 2001, and they exist in Australia, where dozens of immigration detention centres have held so-called boat people from Vietnam and Cambodia, and more recently Afghanistan, in permanent imprisonment, some since the mid-1990s. Okay, so there are many of these detention centres around the world in rich and poor countries, and they have been there for a few decades, most of them. So where do we go from here? What I'm suggesting is that we need to rethink our conceptual socio-legal frames and jurisprudential thinking, which remain deeply constituted through relations to land, property, and territory. In other words, we need to move beyond thinking of law as primarily defining and defending geopolitical boundaries, geopolitical islands of nationalist identity, since these islands are and always have been artificial constructs of the modernist era. This shift in thinking means appreciating that millions of people around the world are living and experiencing life not with some affiliation and affection for a sovereign territory, but are at sea, in a metaphoric sense, in that they live in a deterritorialized world of flows and processes and violence and dispossession, which relations to land may be very fleeting and very ephemeral. This is an image from the Berlin Wall. It's an amazing image on a big concrete wall. In a post-national world, millions of people are far removed from legal protections of any sort precisely because laws are tied to lands, and lands correlate to sovereign states from which they are shut out or expelled. And then, of course, there are millions of people who are literally, not figuratively, literally at sea, trafficked across oceans, enslaved on fishing fleets, bobbing for their lives, be it in the Mediterranean Sea, Indian Ocean, or South China Sea. For these people, access to legal protections is pure fantasy. And then there are those whose lands are being subsumed by rising sea, who are being slowly overwhelmed and swallowed up by warming waters. These are the people living in the archipelagos of islands across the world's oceans, the so-called climate refugees. Under our current socio-legal thinking, as these people's lands sink beneath the waves, they also must necessarily lose their law, their legal identity, and their capacity to evoke rights as subject citizens. Ideals of a social contract are literally subsumed under the waters. There's a couple of images. Together, these various sectors of humanity experience life literally and figuratively at sea. They are, in short, people occupying the seas of humanity that ebb and flow across time and space, denied legal access and resources, and which we as socio-legal scholars will have to come to terms with somehow as we move into the middle decades of the 21st century. In thinking about law's complex relationship to land and sea, John Gillis's book called Islands of the Mind, How the Human Condition Created the Atlantic World, offers some very interesting insights. This is a very fascinating book, Islands of the Mind. And in that book he writes, and this is a quote, "Islands are among the features of the landscape that are indispensable to Western thought processes. Along with mountains, seas, and rivers, islands provide metaphors that allow us to give shape to a world that would otherwise be formless and meaningless. Western culture not only thinks about islands, but thinks with them. Western thought has always preferred to assign meaning to neatly bounded, insulated things, regarding that which lives between as a void. We not only think of our individual selves as islands, but conceive of nations, communities, and families in the same insular fashion, ignoring that which connects in favor of stressing that which separates and isolates." That's the end of the quote. Gillis goes on to talk about this binary between land and sea, with the sea acting as a metaphor for lawlessness, chaos, and instability, while in contrast, islands, lands, present order, safety, and legality. So I want to suggest, drawing on Gillis's thoughts here, that we need to move past this conceptual binary binary of land as lawful and the sea as lawless, and recognize their mutually constitutive relationship. In other words, we need to open up our socio-legal imaginations in order to transcend the prevailing Western epistemological map that reifies land and disregards the sea as embedded within the very concept of what we regard as legitimate legality. This means embracing a more holistic global imaginary to focus on what connects in favor of stressing that which separates and isolates. But how we go about this process of liberating our socio-legal frameworks is not entirely clear, nor would I ever presume that I have a notion of how to proceed. But I imagine it will involve taking seriously unfamiliar, perhaps non-Western understandings of law and legal meaning that emerge from the bottom up within localized sites that foreground peoples and the collective humanity. What I've been calling a global socio-legal perspective does make it clear, however, that we will have to take seriously legal challenges that decenter the authority of the nation state, which is increasingly not working in the best interests of emerging post-national populations, such as this image suggests. So, by way of conclusion, I want to return to the past to think about the future. Today's crisis, the so-called crisis, echoes in some ways the latter half of the 19th century, which was also a period of extraordinary violence and upheaval erupting across Europe as nation-states consolidated their borders and defended nationalist ideals. And remember, Italy and Germany really only became modern nation-states in the 1860s and 70s, very, very recently, relatively recently. And it was a very turbulent period, 1848. As we know, revolutions erupted right across Europe, and it was an extremely topsy-turvy time in which there was much violence. A person from this period who has always caught my attention is that of the radical French artist Gustave Courbet. Courbet was involved in the Paris Commune of 1870 and prosecuted for his championing of the destruction of the Vendôme column, which had been erected earlier by Napoleon. This is a photo which I think is fantastic, and you can see there the column was pushed over and shattered. For Courbet and thousands of working class Parisians, the column represented an imperial symbol of war, greed, and laissez-faire capitalism. So there has an era in the later half of the 19th century in Europe that really has a lot of echoes in our contemporary laissez-faire capitalist, latent liberal moment. Threatened with imprisonment, Courbet fled France and died in exile a few years later. So it's a tragic tale. He really was one of these heroic figures who stood on the battlements with the Parisian working class. He painted many, many pictures of waves. He was fascinated with waves and rocky coastlines, and art commentators at the time interpreted these wave paintings as representing the rising power of democracy about to crash onto the shores of France. More recently, the German art historian Klaus Herding has argued that Courbet's wave paintings symbolized an argument in favor of social equality, in which the sea stood as a metaphor for the people. Taking a cue from this interpretation, I would like to urge us to view the sea as a metaphor for humanity that challenges our socio-legal thinking. For legal theory, as we currently know it, has difficulty in conceptualizing law in borderless worlds of oceans and rivers, not to mention cyberspace and outer space and other spaces that are not grounded and linked to land. My hope is that the horrifying materiality of rising oceans won't drown innovative thought, but instead provide reflection on the inadequacies of our legal frameworks and nurture thinking about what deterritorialized democracy may look like in the future. And if nothing else, I'm hoping that the vast horizons of our seas affirm a sense of openness and fluidity that counters the growing calls for walls of exclusion and islands of legal insularity. So that's it. Thank you.